review of the transportation impact study scoping meeting application dated December 6, 2016. Exhibit B24 is a 5-page presentation of the Battle of Brandywine, flanking movement of Cornwallis impacting Crebilly, prepared by Sean Muir of Western Heritage Mapping. And Exhibit B25 is a review letter from Cedarville Engineering Group, the Westtown Township Stormwater Management Consultant, dated February 22nd, 2017. That's our board exhibits for this evening. A couple of other housekeeping matters that we need to go over for this evening. I want to discuss a little bit about how this format is different than what many of you have already experienced with the Planning Commission. So the Planning Commission is a much more informal process. This evening's process and all the hearings that will follow is a formal on-the-record proceeding. The witnesses will be under oath, their testimony will be transcribed by the court reporter, exhibits will be offered into evidence. That's an important distinction from the Planning Commission. The Planning Commission has the luxury of having a bit more of a dialogue with their proceeding than the board does. Here it is incumbent upon the applicant to make a record, as any other party must as well, in the event that this case goes on appeal to the Court of Common Pleas of Chester County. The reason for that is no additional evidence will be taken at that level of appeal absent a request being granted by the court. So the decision of the court and the review is bound by the evidence that is presented at these hearings. There will be much less conversation with the Board of Supervisors than you had with the Planning Commission members. They will ask questions. In this scenario, they are essentially the judge. They have to make the decision. Unlike Planning Commission members, the supervisors are elected to this position. Planning Commission members are appointed by the Board of Supervisors. So essentially, the buck stops with the board. We have a court reporter for these proceedings. That's important not only for building the record, but also I'll remind you, and you'll probably hear it several times, as good as a job as Eleanor does up here, she can only take down what one person is saying at a time. She'll do her best to take down more than one, but she can't do it. For our witnesses, we often in conversation have a habit of answering the question before it's over, because we anticipate the answer. We know what the question is that they're asking. I need you to do me a favor, let the question get all the way out, get it asked, and then answer, so that we don't have two people speaking at the same time. Let's talk a little bit about the law that we're bound by here this evening. So for a conditional use hearing, the applicant bears the burden initially. It's their responsibility, it's their show. Conditional use applications presume that the particular type of use, and here this evening it's for dwellings, does not of itself adversely affect the public interest. That's not me saying that, that's the Pennsylvania courts saying that. When addressing a conditional use application, the supervisors must employ a shifting burden of persuasion. What that means is, Toll Brothers, as the applicant, must first persuade the supervisors that the proposed use of this property for the dwellings is a use and a type permitted by conditional use, and that that use complies with the requirements in the ordinance for the conditional use. Those requirements are extensive, as you're going to hear. So it's the applicant's burden to present the evidence that shows how they comply with those requirements. Once the applicant does that, once it meets its burden, a presumption arises that that use is consistent with the general welfare. The burden then shifts. It shifts from the applicant to the public at that point to rebut the presumption by proving to a high degree of probability that the proposed use will adversely affect the public welfare in a way that is not normally expected from the type of use. The reason for this is the Board of Supervisors, through their legislative discretion, whether it's this board or a prior board, has already determined in their discretion that the use in this area is permitted so long as the applicant demonstrates that they are complying with the objective criteria of the ordinance. Once that happens, the burden then shifts to the public to show how or if the application is a detriment to the public welfare. So that's a little bit about why we're here. Now, I presume the reason we have so many people here this evening is because of the importance of this application, which we all recognize. I know many people here this evening would like to seek party status in the hearing. So let's talk about how that's going to go, because that's going to be probably a large portion of what we're going to do this evening. Under the municipality's planning code, a party shall be any person affected by the application who has made a timely appearance of record before the supervisors, and any other person, which includes a civic or community organization, permitted to appear by the board. Please understand that just because you request party status does not mean you are granted party status. The applicant is permitted to challenge your request, and he's also permitted to ask you questions about how you are affected by the use. You have to demonstrate that. So when you come up and you ask for party status and you tell us your reasons why and where you live, Mr. Needleman is allowed to ask you follow-up questions. He's also allowed to object to your status as a party. But ultimately, the decision is up to the board on whether or not to grant party status. In this particular hearing, notice of the hearing was sent to every property owner within 500 feet of the 11 parcels. It was something around 110 different property owners should have received notice. If you are granted a party status, you may be represented by counsel. You'll be offered an opportunity to respond and present evidence, any argument, and you can cross-examine witnesses on relevant issues, and I stress the word relevant issues. You are also permitted to appeal the board's decision if you are dissatisfied with the decision of the board, if you are granted party status. So that's for the parties for this evening. We'll go through that process. For those of you who are not seeking party status or who are perhaps denied party status, you are still guaranteed due process to be heard on the application through public comment. This is a public hearing. You will all be heard. It is important to me, it's important to the applicant, it's important to the board that your voices on this application be heard. That being said, public comment is different than questioning by the parties. So please keep that in mind. All the parties are going to finish putting on their cases first. So there could be several parties. We could have a number of parties before this is all over. So the applicant will put on their evidence. You may hear cross-exam from other parties. Anyone who's granted party status will then have a right to present any evidence that they want to present and witnesses. Once all of that is done, and it could take several meetings, it could take several months, we will open the floor for public comment. And I'll remind you that for every hearing. So we're not going to do public comment at the end of each of these meetings. We're going to reserve public comment until the evidence is done. And to be perfectly frank, given how many people are interested in the hearing, there may be just an entire evening devoted to public comment. We'll see when we get to that point. A couple of other things to discuss, which is questions versus comments that I want to remind everyone for. For anyone who becomes a party to the proceedings, when it is time, please ask a question of the witness. And by that, I mean please do not make a statement when it is your opportunity to ask a question. Oftentimes, you will not like the answer to the question that you receive from the witness, and I understand that. Cross-examination is difficult, even for lawyers. We're not very good at it, so I don't expect anyone to be good at it, especially if it's the first time you've done it. If you don't like the answer that the witness gave you, ask a different question, please. I'd ask that you please not ask the same question 2, 3, 4 times in the hopes that he's eventually going to change his answer. That is unlikely to happen. At the time when you're permitted to ask questions, please do not argue with the witness because you're frustrated by the answer, or with the process, or with the application. Please do not make a comment at that time on your position on the application. You will be given that opportunity. At this point, it's an adversarial proceeding. It's question and answer, question and answer. So this is the major difference between the conditional use hearing and the planning commission process. Speaking of the Planning Commission, I attended several of the meetings. I spoke to the Planning Commission members who were there. I spoke with our zoning officer, with our township manager. I personally would like to commend the Planning Commission and any members that are here this evening for how well the meetings ran. I thought the recommendation was well thought out, but in particular, I'd also like to thank the members of the public. Every report that I received and every observation that I personally observed was that everyone conducted themselves in a very professional manner. I am hopeful, as is the board, I am sure, that that will continue through this proceeding. Essentially, what I'd like to ask is that we disagree without being disagreeable. I understand the passions that are involved with this application. I've lived in the area for 37 years. I know the property very well. Supervisors know the property very well. Everyone knows what's at stake. I would ask that you please do not shout out from the audience. If you hear an answer that you don't like, please try to keep it to yourself or take it outside. And I'd ask that we maintain that level of professionalism and decorum throughout these hearings. For tonight, what we're going to do is we're going to go until about 10 o'clock, more or less, depending upon where the witnesses may be in their testimony. Mr. Needleman has 2 witnesses for tonight. We'll see if we actually get through them or not. We'll take a break around 8 o'clock for 15 or 20 minutes or so that Eleanor can take a breath. We'll hear from the applicant here in just a couple minutes if they have anything that they'd like to offer at the start of the hearing. And then what I'd like to do is begin the party status request period. How I'd like to do that is we have 1 microphone, which is also a little different than we had at Ruston. I'd like everyone to just line up as best as you can, provide us with the form that you have, your name and address, and tell us the reasons why you'd like to be a party. The first group that I'd like to come up when we do it is anyone who received the notice of the hearing in the mail. If you received the notice, you should have been within 500 feet, and I'd like to take you all first. Then we'll take anyone and everyone else who may request party status. As you come up, Mr. Needleman may simply stipulate to some of you as a party. He may not object. At that time, you will be a party to the proceeding. There are some of you, I expect, Mr. Needleman will object to. I'm going to treat you tonight as if you are a party. We're not going to make any decisions on party status this evening. I'd like to go back and reflect and discuss that with the board, and we'll make that ruling first thing at the next meeting in March. Last order of business. This is a public meeting. Is anyone recording the meeting this evening?
Yes.
Yes, sir. Are you audio or video?
Audio, video.
Audio and video?
Yeah.
Okay. Anyone else? All right. Thank you. That's fine. I just want everyone to know that you are being recorded here for the proceeding this evening. Anything else? We're going to do order from the board. Okay. Mr. Needleman, do you have anything that you would like to address at this point?
Thank you, Pat. Good evening. My name is Greg Needleman. I represent Toll Brothers. I appreciate the opportunity to be before the board this evening, as well as before the public. I believe we had a very successful Planning Commission experience going through the application. We look forward to continuing that discussion and those question and answer at some point. So you can't hear. Those question and answer experiences that we went through the Planning Commission, we believe were successful. We'd like to continue that as part of this dialogue as well in the conditional use hearing. Rather than do a formal opening at this time, Pat, I'd like to defer until after we've dealt with all the parties' standing issues. So at that point, before I call my first witness, I'll probably make a short opening, and so I'll turn it back to you to begin the party standing.
That's fine. That's not a problem. Thank you, Greg. All right. At this time, then, anyone who received in the mail the notice of the hearing and would like to be a party, would you please come up to the microphone, hand up your form, tell us your name, where you live, and why you'd like to be a party, please.
Pat, if I I may go
Actually,
off
if
the
you
record.
wouldn't mind, hold on, sorry, just, you can give the forms to my paralegal, Jody. She'll take them down front. Sorry, go ahead, Greg.
If we could go off the record real quick.
Hang on. Okay, we'll go off the record.
Chris, who has the access? You want to take it? Yeah, Jessica's got to go up to the computer to put the aerial up. Thanks.
We're still off the record, so if there's anyone who has not yet filled out a party status form, there are many, many extras out in the hallway for you to complete. Please do that at this time and then bring them up with you, hand them to Jody. She'll take them and collect them for the hearing tonight.
If we want to go back on the record, please. Members of the board and the public, we have, on behalf of Toll Brothers, prepared an aerial exhibit. Let's mark it Exhibit A-0, since we've pre-marked all our other exhibits. The aerial is shown on the board as well as on the overhead projection. There are 3 yellow dashed lines and surrounding the property, which is outlined in red. The first yellow dashed line is the 500-foot radius around the property's perimeter. The second dashed line is the 1/4 mile around the perimeter, and the third dash line is 1/2 mile around the property's perimeter. Toll has prepared this in order to assist in terms of determining standing based on location only.
Thank you. All right, let's begin, sir. Please, your name and your address?
Sure. Bradley Harkins, 1081 South New Street.
Did you give the form to Jody?
Yes.
Okay. And could you just briefly tell the board, first of all, did you receive a copy of the notice in the mail?
Yes, we did. We're right on the outside of the yellow off of New Street. We're right, yeah, on the inside.
And then generally, can you tell the board about how you'll be affected by the application?
Certainly. So my
Can
wife
you-
and I actually,
Point the microphone up a little bit.
sure. My wife and I actually lived there for the last 1.5 years, and we obviously are affected both by the fiscal analysis that was done and the $750,000 deficit to the school district. You know, that would obviously lead to an increase in our taxes. Then also, we live right on New Street, so we're obviously concerned about the increase in traffic, which they still have yet to meet the burden for. And then we are also concerned just, about the building and environmental impacts.
Okay. Mr. Adel?
Just if I may, in order to locate your property, could you just please indicate on the board to your left approximately where your house is located?
We're right here.
Okay, I have no objection.
No objection?
No objection.
Okay. Mr. Harkins it is?
Correct.
Okay, you'll be admitted as a party.
Thank you.
Yes, ma'am. Your name, please. Point the microphone down.
Amy Harkins, I'm just his wife, so we're at the same address. I don't know if you need us listed together or separately.
We'll list you together.
That works.
Thank you. Yes, sir. Your name, please.
Hello, my name is Randall Spackman. I represent the Thornwood Farm Trust on 926 South New Street, 1256 Thornwood Road is my address. We actually are in all 3 boundaries on the lower left side, South New Street, 100% of our property.
Did you receive a copy of the notice in the
I
mail?
own the trust, yes.
Mr. Spackman, would you spell your last name for the court?
Sure, Spackman, S-P-A-C-K-M-A-N.
Sir, do you have a position with the trust?
Yes, I'm the trustee.
And how are you affected by the application then?
Being that we're the largest local property owner, about almost 180 some acres with South New Street running for our property, the concerns are obviously traffic, 926 South New Street intersection, deer management, our trail program that proceeds through our property up through Westchester that we work with Chester County to promote a continuous trail network. It's the end, of course, our farm is the actual side battle Brandywine with Crebilly Farm. So we actually have mass burials and all the different radar imaging from Temple University on our property. and also part of the Hessian movements from Cornwallis.
Thank you, Mr. Spackman. Mr. Edelman, any objection?
Just a quick clarification, Mr. Spackman, are you seeking party status just for the trust?
I represent the trust, so yes.
Right, so I have no objection to just the trust being granted party status.
All right, can you tell me again the proper name of the trust?
Thornbury Farm Trust, and also estate of Herbert B. Spackman. Both titles.
Mr. McKenna, let me ask a question on that then.
Yep, I figured you would.
Which entity owns the property?
They're both
Co-owners?
yeah, exactly.
Okay.
It's just highlighted.
All right, I don't have any objection.
Okay, thank you.
Okay, the trust will be admitted as a party.
Thank you.
Mr. Dufault, good evening.
Good evening. Peter Dufault. I live at 110 Four-Lot Court, Thornbury Township. I'm also president of the Brandywine and Thornbury Homeowners Association. In the capacity as president, I'm requesting that the Brandywine and Thornbury HOA be designated an interested party to the conditional use hearing present before the West Town Board of Supervisors.
Thank you, Mr. Dufault. Did the HOA receive notice in the mail of the hearing?
The manager did, yes.
Is there a property management company for the HOA?
Penco Management.
Mr. Dufault, is there any resolution or corporate action on behalf of the HOA to appoint you or to seek party status?
There is a resolution attached to the application.
Mr. Edelman?
I don't have any objection to the HOA based on their individual